Good evening, everyone. I'm Yuvkashi Grover from Team Lex Templum, and this video is specifically designed to give you an idea and a complete analysis of the criminal law questions which came in the CLAT PG 2020 examination. So there was one passage from criminal law in the CLAT PG 2020 examination, and with respect to that passage, there are some general observations. First is that this time, though the sample paper stated that the passage will be case law based questions, but the comprehension which was there for the criminal law was not specifically based on case laws, but rather it was based on the jurisprudential understanding of criminal law. So for some students who have not read the basic knowledge of criminal law, or who were only able to read and go through the case laws, the landmark judgments, for them, the passage related to criminal law must have been difficult. But again, the questions were approachable as compared to other law subjects which came in the paper. Questions were framed with the objective to test the basic and fundamental understanding of the subject. So it's very important to know each and everything, the basic principles on which the entire criminal law rests. And the same objective was seen in the paper, and all the 10 questions, and itself the passage stated that it was only about the fundamental principles of criminal law. So the entire aim of CLAT consortium was to test the basic and fundamental knowledge of the student through the 10 questions which came from criminal law. The questions were not, as I stated earlier, the questions were not based on the landmark judgments, but again, it were approachable. I will conduct a question to question based analysis in the later part of the video, but as a general observation, the passage was moderate to difficult depending on the number of questions I will be discussing further. And when we come to a general observation, again, there were 2 questions which were specifically based on case laws, not any recent or landmark, any recent case law or a specific excerpt of the case law, but they were based on the landmark case laws of criminal law. 4 questions were specifically and directly related to criminal law jurisprudence. 2 to 4 questions were based on your legal awareness of criminal law. I will explain you on a question to question basis now. So this was the comprehension which came in the question paper specifically with criminal law. Now when you read the comprehension, it is general comprehension. It talks about the fundamental and basic principles of criminal law. There is no specific principle or a specific case law given in the passage. So it's easy to understand the passage, but then to answer the questions, you should know, again, I'm telling the same, you should know the basics of criminal law. The first question was, which of the following reformed criminal law? Now here there were 4 options given. The correct option is Malimat Committee report. The second option could not be the correct answer because this was related, Justice M.N. Venkatacharya Committee was also known as a National Commission to Review Working of the Constitution. So who have ever read about the commissions or committees in a general awareness part, that student would have approached this question. Even a student who has read the 377 judgment or the adultery landmark judgment, Malimat Committee report was again and again referred by the court in these 2 landmark judgments. And these 2 landmark judgments were there from criminal law. And if a student has approached or has even tried to read this judgment, then this question must have been approachable for that particular student. Now the 52nd Law Commission report is also not related to criminal law. So B and C and D cannot be the answers. So the answer here is Malimat Committee report. Now a person who has seen a glimpse of section, who was able to see a glimpse of section of the case on section 377 or the adultery judgment would have answered this question, because again and again Malimat Committee report was referred in these judgments by the Constitution bench. Second question was a memory based question. It was not a general question or a question of criminal or a criminal or a question of logic reasoning where you can apply reasoning and answer the question. Again, if you know who has said this, then you know the answer. And the answer was James Stephen. Now here also, if a student has read criminal law, the basics of criminal law, or the the concept of culpable homicide and murder, then this particular line which states that the line which is given in the question, that is culpable homicide the genus and murder the species, are defined in terms so closely that it is difficult to distinguish them. So a person who has read jurisprudence in relation to the concept of murder and culpable homicide must have been able to answer this question. So this question was specifically and entirely based on your memory and the concept. If you have read the concept thoroughly, then this question was also approachable. Though this question was not as easy as you thought or was not based on the bare language, but again, a student who has read the concept properly, the basic concept of murder and culpable homicide, will be able to answer this question. The third question. Now here, though the answer is not mentioned in the passage itself, but the question is directly linked with the passage, and when you apply a simple reasoning here, you will be able to answer this question. I'll explain how. Lately, Indian criminal law has been moving away from the above mentioned classical principles of criminal law. This statement will help you to pick the correct answer in this question. The question is, which one of the following does not demonstrate this shift? Now here, once on the first reading, you might have this conception that the answer is there in the passage itself, but no, the answer is not there in the passage itself. The first line simply states that the above mentioned passage, that is the comprehension which was there in the examination, talks about the fundamental principles of criminal law, and there is a shift in these principles. So you have to answer, you have to choose the correct option which is not demonstrating this shift. Now the correct answer is creation of new crimes. I will tell you why the other three options are correct. Because in questions where you have to answer the not part, that is the odd one out part, your approach towards the question should be different. So here I'll try to explain you that why the other three options are correct and are demonstrating this shift. First is shift in burden of proof. Over the year, criminal law has evolved. We have IPC of 1860 itself, that is a British time IPC. But again, the definition of different crimes, the concept of different crimes have evolved, and the shift in burden of proof has also evolved. So the B option cannot be the correct answer. C is presumption of guilt. The principles of presumption of guilt in the Evidence Act as well as the IPC have evolved in different cases. When you must have read the 377 judgment, all the adultery judgment, even the recent cases involving these principles of criminal law, then you must have seen that yes, there is a shift in determining the presumption of guilt. Now fourth, broader definition of crimes. D option cannot be the correct answer, because yes, there is a shift, and there is the definition of crimes have been evolving from on a time to time basis. For this, I can give you an example of the rape laws or any laws you constitute. Even the adultery judgment itself is a biggest example, which states that there is a shift in the pattern in the definition of crime now in India. So that is the reason these three options are not at all correct. Now, why creation of new crimes is correct? IPC is a British law. It's a law which was formed in the British time. But again, we are not creating new crimes. We are evolving the application of these crimes. The criminal law is evolving in a way where the ambit of crime is broadened, not a new crime is introduced. That is the reason option A is correct. Next question is, again, this question is a subjective question. And this question also created confusion in mind of every individual student, because this to answer this question you must have a subjective approach. So it's safer to skip these questions when you have no clue to these questions, because there is negative marking in the examination. But there is a trick to solve this question. And when you know the trick, it's easy to approach any question you have no idea about. The accused must be given death penalty to satisfy the collective conscience of the society. This is the statement. Here, keywords are satisfy the collective conscience of the society. That means we are talking about society, the entire society. Is this the correct method of determining sentence? Now, don't go to the options first. Try to understand the question. We are on one hand, the statement is talking about the collective conscience of the society, plus collective conscience of society in relation to awarding death sentence. So here, first to determine whether the answer should be yes or no, it is important when a student reads the the basic fundamental principles of criminal law. First, even the concept of punishment. When you read the sections based on punishment, the first concept to read is that punishment is never granted on the collective conscience of the society. Society and punishment, these two factors are irrelevant and are not interrelated. So here, yes cannot be the answer. So option A and option C is directly out of the link. Now you're left with two options. That is B, that is a straightforward no, and D, no as what others think is irrelevant in deciding punishment. Now here a student gets confused that whether to opt for the simple option that is stating no and be in a safer zone, or opting for an option which is providing a reason also for that no. So in this situation, when you're stuck between two options, you should consider the reasoning given in the fourth option, that is as what others think is irrelevant in deciding punishment. So this is the basic principle of criminal law, that whatever the society thinks, this cannot be a ground of granting any kind of punishment. So this best suitable answer for this question is D only, because no, as first I told you that you have to decide between yes or no first. Once you decide that the answer is no, then you will see the reasoning, and the reasoning given in the option D is correct. That is the reason the most appropriate answer for the question is option D. Then the next question. In determining the sentence, which of the following factors are to be taken into consideration? Here there are three concepts given in the options. First is aggravating factors, second is mitigating factors, fourth is collective conscience of the society, and then the last you have the C options, that is both aggravating and mitigating factors. So first you should know what exactly aggravating and mitigating factors are to answer this question. If you are unaware about this, then first of all you should not attempt it, because it's negative marking. But if while reading and while preparing criminal law, if you have seen that in some cases these have been discussed, that both aggravating and mitigating factors should be considered while determining the sentence. So if you have read somewhere, then you should try to attempt it. Otherwise, skip the question. It's better to not answer the question if you are unaware entirely about the topic. So here the correct answer is both aggravating and mitigating factor, because aggravating factors define that which factors increase the severity of culpability of any crime. So example, the nature of the crime, the injury suffered by the victim, other factors are aggravating factors, etc. These factors are aggravating factors which help you to determine that what is the culpability level of the crime committed. And mitigating factors help you to determine that what type of sentence should be awarded for the crime. So sentence and the nature of crime, these both are important, and both are determined by the aggravating and mitigating factors respectively. So the correct answer for this question will be option number C. Then this question was case law based question. Now I have highlighted the important lines through which you should have answered the question correctly. So going to the question, the Supreme Court itself admitted in Santosh Kumar Beya case, that is a 2009 judgment. Now here you should not panic after reading this line if you're even if you're unaware by the Santosh Kumar Beya judgment, because the answer to this question lies in the question itself. I'll tell you how. That death penalty is imposed arbitrarily or fiscally. So arbitrarily and fiscally, keep this in mind. The court made a candid admission in saying that there is no uniformity of precedent. Again, moving forward, in Sangeet 2013, again, if you don't know anything about the judgment, don't panic. The court yet again acknowledged that principal sentencing has become judge-centric. So, has become judge-centric is the key word here. Okay, moving forward. In Swami Shraddhananda 2008, the court said a word of death sentence depends on the personal predilection of judges. This is again a catch here. And there is lack of uniformity in capital punishment. So you have 4 catches in the question itself to answer this question. Which of the following statements is correct? Now you have to answer that which statement is correct. I'll be reading the options first, and then I'll tell you that how these 4 catches will help you to answer the question correctly. First is, award of death penalty depends on law and is given in rarest of the rare cases. Though this option has 2 parts. First part talk about death penalty depends on law and is given in rarer of the rare cases. Okay, these are 2 parts. Come to the next option. Award of death penalty depends on personal ideologies of judges. So there are 2 options. Now a student may be confused that both the options are correct. So the right option should be C, that is A and B both are correct. But again, I'll tell you to go back to the question again and follow that 4 catches, which I have marked, which I have I have bolded. All the 4 options given, all the 4 catches in the question talks about judge opinion, prediction of the judge, predilection of the judges, or lack of uniformity. That means that death sentence is awarded on the basis of the predilection of the judges. It is arbitrary or fiscal. So every catch is talking about the judges' ideologies. So the best suitable answer according to the question statement given will be option B, not option A. So that is why option B will be the correct answer. So to remove confusion, you should go and at the time of the examination, you should read the questions again and again. Sometimes the answer is there in the hidden in the question itself. So here for this question, the correct answer was award of death penalty depends upon personal ideologies of the judges, because all the above mentioned statements in the questions talk about the individual ideologies of judges, and that is why B is the best suitable answer. Next, this question is again a judgment based question. In Machi Singh 1983, this is a landmark judgment. A 3-judge bench listed 5 parameters to decide whether case falls within the rarest of rare, such as the manner of commission of crime. Okay. That is brutality, motive, antisocial or abhorrent nature of crime, magnitude of crime, and personality of victim. That is child, woman, or leader loved by people, etc. Now, question is, which parameter laid by the Constitution bench in Bachchan Singh was left out? Okay. Now, this is a very confusing question. And this question is not a straightforward question, or no straitjacket formula can be adopted to answer this question, because it was little confusing. But again, I'll explain how the answer of this question lies in the question itself. I have highlighted certain things in the question. That is manner of commission of crime. Okay. That is brutality, motive. These constitute the manner how the crime is to be committed. And the parameters, again, don't forget that Machi Singh's talk about the parameters which determine that whether a case will fall in the rarest of the rare cases or not. So the parameter part is already covered by the judgment. Second, the manner of commission of the crime is also covered by the judgment. Okay. Third is nature of crime, magnitude of crime. So these points are already covered by the judgment. And the question asked here is, which parameter laid down by the Constitution bench in Bachchan Singh was left out? Okay, now coming to the options. Impact on first option is too much importance was given to the crime, but criminal was left out. We'll come how this answer is correct. B, impact on society. Now, the question itself states that manner of the commission of crime is covered, nature of the crime is covered, magnitude of the crime is covered. Magnitude of the crime is determined by its impact over the society itself. So, B option cannot be the correct option here. Intent. For a crime, mens rea is very important. Without mens rea, a crime is not a crime. So, intent cannot be an option here. Correct option in this case. Next is weapons used in the commission of the crime. Now, the 5 parameters starts with the manner of commission of crime, with the statement that it covers manner of commission of crime. So, weapons cannot be an option here. So, the best suitable answer for the question would be A, because the entire premise which is given in the question of Machi Singh, of the parameters decided by in the judgment of Machi Singh, states everything about crime, but not specifically criminal. So the best suitable option here will be A for this question. Next, this is again a memory based question. If you know the answer, you will get it correct. If you don't know the answer, you cannot hit around the bush and get the answer correct. So it's better to skip the question if you're unaware about it, because again, I'm repeating, negative marking in the examination. So this definition is specifically given by James Stephen. This is again a memory based question only. Okay, next, this is again analytical question where you have to apply your brains after reading the question once or twice. Justice Fitzgerald observed the law of conspiracy. This question is based on the law of conspiracy. Is a branch of our jurisprudence to be narrowly watched, to be jealously regarded, and never to be pressed beyond its true limit. Now here the catch is the word to be. That means justice is observing that the law of conspiracy should be like this. It's not talking about the present condition of law of conspiracy. It is talking that the conspiracy should be like this. The concept of conspiracy to be. That means he is talking about the idealistic concept of law of conspiracy, not what the present concept states. So here there is a statement given, a principle given, and then a question follows to that principle. Under section 149, mere membership of the assembly without any participation in the crime is sufficient. So the statement is very important. In the light of this statement, this sentence, in the light of this statement, restricts you to keep your thinking only to the statement, only to the ideology of the statement given in the question. Whether punishment of conspiracy by mere agreement and under section 149 by mere presence be deleted from IPC. यहाँ पे ये पूछ रहे हैं कि क्या कॉन्स्पिरेसी का जो पनिशमेंट है सेक्शन 149 के लिए, which states that mere presence is enough to constitute an offense under section 149. This principle should be deleted. Now, it's not talking about that whether it is deleted or not deleted. Sometimes students get confused that what exactly they're talking about. Are they talking about the status quo of the section? No. In the question, it is everything is dependent on to be. The ideology of justice is different from what it actually the law talks about. So here in the first line only the to be word is the catch. Now the question is कि क्या punishment हटा देनी चाहिए, change हो जानी चाहिए, या फिर ये concept evolve होना चाहिए that mere presence will not attract penalty under section 149. So first of all, it's analytical question again, okay, but now you have to get the best suitable answer. In all the questions which involve analytical jurisprudence of criminal law, your ideology of answer the question should be analytical enough at the level of the question. You should not restrict your thoughts while answering these questions. So here, there is no specific answer to the question, but you have to now in these types of questions, you should read the options first and then analyze which is the best suitable answer. So first answer talks about yes, if we believe in liberal and enlightened criminal jurisprudence. Liberal and enlightened criminal jurisprudence. So liberal and enlightened is the keyword here of the option. This is the correct answer for the question, but I'll explain why the other three options are not correct options. B, no if we are a status quo. Status quo means जो है जैसा है वैसा ही रहेगा. तो सेक्शन 149 बोलता है कि mere presence से आपकी liability बनती है, तो आपकी liability mere presence से ही बनेगी. This is the meaning of option B. 3. Option C. No conspiracy must remain punishable by mere agreement. Okay, acceptable. No mere presence should be enough. Okay. So here the catch is all the options related to no are similar in one or the more way. And the option and the reasoning, again, when I told you earlier, in these type of questions where there is yes and no, and you're not able to decide between the two, go to the reasoning given in every option. So your B, C, and D have nearby reasonings to that, and no reasoning is specific enough to give a substantial answer. But if we go by the words liberal and enlightened in the first option, then this option, that is A option suits the best to the question. And that is the reason option A is considered to be the correct answer, because again, the question simply and clearly states in the light of this statement, that is the statement given by justice in the question. So that is why option A is the correct answer. Last, criminal law revision must reflect A option, deterrent theory with the aim to prevent crime, retributive theory consistent with the scheme of victim compensation. C, reformative theory consistent with democratic values and civil liberties. This is again a memory based question, and it is interlinked with the passage above mentioned. So your first option is not correct, because our criminal law is not adopting any deterrent practice with the aim to prevent crime. Our criminal law is evolving in a way to be reformative. And that is the reason C is the most suitable answer for this question. So these were the 10 questions. I hope this video will help you in understanding the pattern of CLAT PG 2020 criminal law based questions. And if you want to prepare for future examinations, then it is most important to understand the pattern of the earlier examinations. Then only you can plan your study and approach towards the examination. So thank you so much.